Welcome to Complex Conversations. In this podcast, we hope to make complex living simple by explaining the law related to sectional title schemes, homeowners associations, and other types of community schemes in South Africa. I'm Jennifer Paddock, a dual qualified lawyer and attorney here at Paddock's, a specialist community schemes law and training firm. In the second episode, I want to apply the principles that I unpacked for you last week in episode 1 on who pays for maintenance, repair, and replacement in sectional title schemes by running through 5 real questions and answers that we received on Paddock's Club. So last week, we dived into the theory, and this week, we're putting the theory into practice. If you haven't yet listened to episode 1, feel free to hit pause now and go and listen to that episode first, or simply continue to listen to this one, as some of the principles do pop up again in this episode. So let's get started with question 1. Leak from section above causing damage to section below. This was a question from a managing agent who said that an owner of a scheme they manage had notified them of a leak into the section coming from what they thought was something in the section above. The water meter servicing the section above was switched off with the stopcock, and this confirmed that the water leaking into the section below was in fact coming from the section above, as the leaking stopped when the water was switched off to the section above. The owner of the section above was notified of the water leaking into the section below and asked to have a leak detection service done so that the source of the leak could be identified and repaired. The leak detection was done, and the water pipes servicing the basin in the bathroom were found to be leaking in the wall, causing the leaks into the section below. The owner of the section above has now fixed that leak, but is not prepared to pay for the resultant damages caused to the section below. Could you please assist in providing a response as to the owner above being responsible for the damages to the section below, as this will likely end up going to CSOS or an attorney by the owner with the damage to their section? Okay, so in answering this question, I want to just start by saying that the Sectional Title Schemes Management Act apportions the legal responsibility for maintenance and repair of property in a sectional title scheme to either the body corporate or the section owner, okay? And it does not deal with responsibility for consequential or resultant damage, which is what we're dealing with in this question. So Section 13(1)(c) of the Sectional Title Schemes Management Act requires an owner to maintain and repair their section in a state of good repair. So as such, the owner of the section with the leaking basin, so the section above, is responsible to fix that leak in their section to keep their section in a state of good repair, which this owner above has already done, okay? The owner of the section below, who has the resultant damage, is responsible in the first instance, because of Section 13(1)(c), to fix the resultant damage in their section and to put their section back in a state of good repair, okay? So in terms of the Sectional Title Schemes Management Act, in the first instance, the owner of the section above must fix their section and the owner of the section below must fix their section. There's no automatic responsibility for the owner of the section above to pay for the resultant damage to the section below. However, the owner of the section below, while still responsible for the repair of their own section, would have a delictual claim for the reasonable cost of their repair from the owner of the section where the leak originated, okay? And this is because the law of delict allows a person who has suffered loss as a direct result of another's acts or omissions to claim compensation from that person, okay? So essentially, in the first instance, each owner must pay for the repair of their own section, but because the section below was damaged as a direct result of some act or omission of the owner above, the section below will have a claim against the owner of the section above for the reasonable costs of repairing that resultant damage which was caused from their section. Okay, now how to go about getting the money back from the section owner above if that person is not willing to pay? You would hope that, somebody would be reasonable, and if there was a leak in their section and if there was proof that their section had damaged the section below, that person would pay. However, in this case, it sounds like the section owner above is not willing to pay. So what would the section owner below do? If after, some reasonable attempts to get the section owner above to pay and that kind of leading nowhere, the section owner, the owner of the section below, would make an application to CSOS, the Community Schemes Ombud Service, to recover the reasonable costs of repairing the damage from the owner of the section above. So there is, in terms of Section 39(6)(b)(2) of the CSOS Act, the applicant or the owner of the section below could apply for an order requiring the relevant person, the owner of the section above, to pay the applicant an amount fixed by the adjudicator as reimbursement for repairs carried out in respect of the property of the applicant. Okay, so that would be the prayer that the section owner below would use when making application to CSOS. Now, there may be insurance implications here. Perhaps the owner of the section below institutes a claim with the body corporate's insurance for the repair work to be done to their section. And if the insurance claim was approved and then the body corporate's insurance actually funded the repairs, maybe the owner of the section below would only be liable for the excess, if any, in relation to that claim. And in that case, then the owner below would be claiming the quantum of the excess from the owner above rather than the cost of the repairs. Okay, so let's move on to question 2, which is damp inside a section from water ingress from the common property. So an owner has resultant damage to their section, which has occurred over a period of time due to water coming into their section from the outside of the building. The owner never reported the water ingress and has since sold his unit, and the new owner reported it to the body corporate seeking resolution. Neither of the owners had communicated to the body corporate in respect of the damage and repairs required until recently, when the matter had already escalated in terms of the damage caused with damp and mold visible inside the unit. Due to the delay in advising the body corporate of the situation, who would be liable for the damage in the flat? Okay, so as we've already discussed, the owner of the section is legally liable to repair the interior damage because of section 13(1)(c) of the SDSM Act. But that person would have a claim, a delictual claim against the body corporate if they could show that the moisture had entered their section due to a failure on the body corporate's part to properly maintain the common property. Because remember, the outer skin of the building is generally always common property because the section extends to the median line, which is the midpoint of the section boundary wall. And that means that the outer skin is actually common property. So if there has been water ingress from outside the building into a section, that's generally coming from common property. So if you can show that the body corporate has failed to properly maintain the common property, then, and that has caused damage to your section, then you will have potentially have a delictual claim against the body corporate for the reasonable costs of repairing the damage inside your section. And the body corporate is responsible to repair and maintain the common property in terms of section 3(1)(l) of the SDSM Act. But in these circumstances where the body corporate, has not been told of this problem and owner of the section has been aware of it for quite some time, the body corporate may have a counterclaim against the person who owns the section if they can show that that owner unreasonably delayed reporting the damage to the body corporate so that it could take remedial action on its side to fix that common property defect. So in other words, the CSOS or a court may find that the owner was negligent and has contributed to the cost of the internal repairs. So these things can get quite complicated, for example, where there's been a delay in reporting the issue, but each case will, be considered on its own merits. Let's move on to question 3, broken window replacement. One of the window panes is cracked at a block we manage, and the owner wants the body corporate to pay for it. The exterior of the windows has always been maintained by the body corporate, and there is no indication of what caused the break. Who is responsible, as this is not maintenance related? And the answer to this is that if the cracked window is in a wall that is shown as a section boundary, a solid line on the scheme sectional plan, the median line runs through that window, and that's in terms of section 5(5) of the Sectional Titles Act. And as such, the cost of replacing the window should be split 50-50 between the body corporate and the section owner. So when we talk about doors and windows in section boundary walls, there's always a median line running through those windows and doors, which means that the window or door is always 50% common property and 50% section. And obviously we know section 13(1)(c) of the Sectional Titles Act makes the owner of the section responsible for their section, and 3(1)(l) makes the body corporate responsible for the common property. So it's 50% common property, 50% section, and therefore the costs of repair, replacement, and maintenance need to be split 50-50 between the owner and the body corporate. So that's that one. What about insurance excess in this case? Okay, so if the window is located in the section boundary wall, then as we've mentioned, the median line runs through it, which means that it's half section and half common property. Prescribed Management Rule 23(2)(b) states that a member or an owner is responsible for any excess amount that relates to damage to any part of the building that the member is obliged to repair and maintain in terms of the Sectional Title Schemes Management Act or the prescribed rules. So in this case, half the window is section, and so the section owner is responsible for half the costs of the excess. Okay, question 4, leaking windows on enclosed patio, enclosed without permission. So I'm throwing in some curveballs here just so you can see how these kind of repair and maintenance issues can get quite hairy in practice. I've just received a WhatsApp and photos from a relatively new owner in one of the complexes I manage. She's asking whose responsibility it is for leaking aluminium windows on her enclosed patio. The patio was illegally enclosed years ago, long before I started managing the complex, and the aluminium windows were put in then. Am I correct in saying that this is the owner's responsibility, or does it fall 50-50 with the body corporate? And the answer to this is that the 50-50 principle only applies when the windows are in the section boundary wall as shown on the registered sectional plan. And that's when the wall and windows are 50% section and 50% common property. In this case, that doesn't seem to be the case. And if this is correct, then the body corporate is not responsible for any share of the cost of these windows, okay? Also, in this case, you may want to recommend that the trustees consider whether they should be taking steps to have the illegal patio made legal, either as an extension of the section or perhaps having it made subject to exclusive use rights. Let's move on to question 5. An owner has a crack running from floor to ceiling in an internal wall between bedroom and lounge. They are concerned that this may have been caused by movement of the building due to a landslide or other causes which may have compromised the structural integrity of the building. No other owner in the scheme has reported similar cracks. As this is an internal wall within a section, would the onus be on the owner to employ the services of a structural engineer to inspect, which is what the owner is suggesting? Or is the onus on the body corporate to engage a structural engineer, bearing in mind that this is an internal wall? Either way, if the structural integrity of the wall has been compromised due to movement of the building, must this be repaired by the owner of the section or by the body corporate? The answer to this one is that the onus is on the owner to confirm that the cause of the cracking inside their section is emanating from the common property. So the owner must pay for the structural engineer's report. And if the report confirms that the common property is in fact the direct cause of the cracking, then the body corporate would be responsible for repairing the common property defect, which is section 31L of the STSM Act, and the owner would have a claim against the body corporate for the reasonable costs associated with the engineer's report and repairing the cracks. Because remember, in the first instance, the owner of the section is responsible to repair the section, section 13(1)(c), so they would be responsible for repairing the crack, but delictual claim if they can show that the crack was caused as a result of some act or omission on the part of the body corporate, some defect in the common property, and they would be able to claim the costs of the engineer's report and the repairs of the crack, the reasonable costs of those things. Okay, so if the body corporate fails to effect the common property repairs, the owner could make application to CSOS under section 39(6)(a) for an order requiring the body corporate to have the repairs carried out. So the bottom line here is that the STSM Act apportions the legal responsibility for maintenance and repair of the common property to the body corporate and maintenance and repair of the sections to the owners. It doesn't deal with responsibility for consequential or resultant damages, as we said before. So the body corporate is not automatically responsible to repair damage inside sections caused by a failure of the common property, but the owner concerned is entitled to make a claim for the reasonable cost of the repair from the body corporate, or, as we saw in question 1, from another owner. Likewise, the owner whose section is damaged by a leak from another section is entitled to claim the costs of the repair from that other owner. I hope that's been helpful, and I will see you next week for another episode.